Thank you so much, Mindy, and it's good to be with Ceres today for this investor briefing. Let me just say, as is customary, I'd like to note that my views are my own, and I'm not speaking on behalf of any of the staff or fellow commissioners. So that's out of the way. As you all know by now, as Mindy said, in March, the Commission voted on a proposal to mandate climate risk disclosures by public companies. Let me try to put this proposal into the context of our long tradition of disclosures. The core bargain from the 1930s was and still remains that investors get to decide which risk to take. And as long as public companies provide full and fair disclosure and are truthful in those disclosures. And over the generations, the SEC has stepped in when there's significant need for the disclosure of information relevant to investors' decisions. And that's where we are right now, by the way. The first disclosures revolved around companies' financial performance. Who runs the company, how much the company's resources were dedicated to paying the executives and the like. In addition, over time, historical information, though, investors wanted to assess risk as well. Risk, by definition, often involves events that have not yet occurred, the future. So back in 1964, the SEC started to offer guidance about disclosure of risk factors. The agency later adopted disclosure requirements related to management discussion and analysis, late 70s. Then they also added environmental related disclosures dating back again to the 1970s. The Commission elaborated on all of these requirements in subsequent decades, but also in 2010 put out guidance regarding climate-related disclosures. Across all of these disclosures, the same principle applies again and again. Investors get to decide which risks to take as long as the public companies provide full and fair disclosure and are truthful in the disclosures. Further, the SEC has a role to play, as it has for 88 years, as it can now, play a role in bringing some standardization to the conversation, which is already happening between issuers on the one side and investors on the other side, particularly when it comes to disclosures that are material to the investors. And in making decisions about disclosure requirements under the federal securities laws, including decisions about the proposed climate-related disclosures, I am guided by our three-part mission: protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation. But I'm also guided by that concept of materiality. And as the Supreme Court has explained, information is material if, quote, there's a substantial likelihood that a reasonable shareholder would consider it important, end quote, in making an investment or voting decision. Or they went on and said, does it have, quote, significantly altered the total mix of information made available, end quote. Forward-looking statements such as forecasts and risk also can be material. And their standards, both from the Supreme Court and the Commission, have articulated this. I believe the proposed rule would build on that long tradition. It would provide investors with consistent, comparable, and decision-useful information for their investment decisions. It's up to them, their decisions, but it's consistent, comparable, decision-useful information for investment decisions and provide consistent and clear reporting obligations for issuers. So now let's look at today's practices. Here's the thing. Climate disclosures are already happening. And today, investors are already making investment and voting decisions using information about climate risk. Today, hundreds of companies are already disclosing information, and that conversation is already going on. Many of the existing disclosures build upon, as Mindy said, the Task Force on Climate-Related Financial Disclosures, TCFD, and the Greenhouse Gas Protocol. Let's look back, though, for a second. The TCFD was formed in 2016. They published their report in 2017, reporting into the Financial Stability Board of the Group of 20. The task force, though, comprised then and now about 30 plus market folks, not government officials, market folks, investors, and issuers, some academics who came together to create a climate disclosure reporting framework. 5 years on, this TCFD framework has been used by thousands of companies across the globe as a basis for reporting climate risk information. And beyond that, many countries already have started to develop reporting regimes to build on and incorporate that framework, including Brazil, the EU, Hong Kong, Japan, New Zealand, Singapore, Switzerland, and the UK. One report actually found that 70% of companies in the Russell 1000 index, that's here in the US, published sustainability reports in 2020 using various third-party standards, which includes information about climate risk. SEC staff, as part of our work, actually went back and looked at 7,000 annual reports from 2019 and 2020 and found that a full third included some disclosure related to climate change. Today, investors representing literally tens of trillions of dollars support climate risk disclosure. I don't really need to say it to this group because so many of you are those investors. And why is that? It's because you all, investors, recognize that climate risk can pose significant financial risk to companies. And investors need reliable information about those risks, those climate risks, to make informed investment decisions. For instance, investors with $130 trillion of assets under management have requested companies disclose climate risk. And that information can influence shareholders' evaluation, risk management, investment decisions to buy and sell and vote proxies. So companies and investors alike would benefit from clear rules of the road in the release. I believe particularly those rules reflect what is becoming widely accepted around the globe. It makes sense to build on what so many companies are already doing to enhance, again, consistency, comparability, decision usefulness. So let me just say a few words about the proposal, and I'm sure your briefings today will give you more. The proposal thus really draws on this long tradition of what's currently happening. First, we looked at this and said, these disclosures ought to be, and this is the proposal, be filed in the 10K rather than solely on a company website or elsewhere. And you might say, why? Well, investors look for relevant information in filings like 10K when assessing an investment decision. That was true when I was on Wall Street several decades ago. It's true now. It's true of the management discussion and analysis sections. It is true of the risk factors I mentioned that came about in the 1960s. It's true of the environmental disclosures that were started in the 1970s. It's true for other key disclosures today. It is important that investors be able to find consistent, comparable, decision useful information in one place rather than sort of looking around and having to piece together information from different locations that might in turn differ from one issuer to another. How do you do consistency unless you have it in a similar place? Further, placing disclosures in filings also benefits investors because there are more controls around the disclosures with a framework required under the Sarbanes-Oxley Act called Section 302. Now, there are some costs to this, but on balance, I believe this consistency, along with the enhanced control environment, brings greater benefits and efficiencies to these disclosures. But we look forward to hearing from you on that, of course, in your comments. Now, a few days after the SEC's proposal came out, the International Sustainability Standards Board made its own proposal on climate related disclosure requirements, and it too proposes the climate disclosures as part of the general purpose financial reporting. This is just amongst one of many similarities to what we put out. Now, in terms of the disclosures themselves, not the placement or location, but the disclosures themselves, first starting with strategy, governance, risk management, and targets. This helps bring some consistency and comparability to what the management teams are already disclosing: strategy, governance, risk management, and targets, building upon the TCFD framework. The second is disclosure for companies that set targets or use internally developed target plans, transition plans, scenario analysis, carbon pricing as part of their risk management. If you, the reporting company, and there are reporting companies listening here today, have a target Under the proposal, you'll need to disclose your plans to get that target, If you have a transition plan, you would need to provide disclosure about the plan. If you employ scenario analysis or internal carbon pricing as part of your risk management, then again, disclosing that as well. But it's up to the company to determine whether to have a target, whether to have a transition plan, a scenario analysis, carbon pricing. If a company chooses not to make those statements or use those tools, no disclosure would be required. The decision on whether to make those statements or these statements or use the tools, though, remains entirely up to the company under the proposal. Again, we want to hear about that. But to the extent that the proposed disclosures would include some forward-looking statement, such as projections about future risk or related targets or transitions, the forward-looking statement, safe harbor in a law that was passed 25 years ago, the Private Securities Litigation Reform Act, would apply to these forward-looking statements. So we have a disclosure-based regime, not a merit-based one. Thus, the design of the proposal is consistent with those long traditions and the law, with concepts of investor decision-making and related materiality, and with what companies are already doing based on TCFD and the GHG protocol. Second area of disclosure, the first one was pretty big, I know, but second area is financial metrics. The proposed rule also would require a company to disclose, quote, certain disaggregated climate-related financial statement metrics. These are the ones mainly derived from existing financial statement line items. This would include the impact of climate-related events and transition activities on the company's consolidated financials, the current financials. Not so much about the future, but the current. And then next, greenhouse gas emissions. The proposal addresses this because, again, investors are already looking at this and making investment decisions around greenhouse gas data. And such data could present risk, climate-related transition risk. So the risk could include regulatory, technological, market risk driven by transition to lower greenhouse gas emissions in the economy, which has potential financial impacts on revenues, expenditures, capital. The proposal has that all filers would disclose what's called their Scope 1 and Scope 2 greenhouse gas emissions, emissions that result directly or indirectly from facilities owned or activities controlled by the registrant. Thus, these data should be reasonably available to issuers. Now, about Scope 3. Under the proposed rule, some registrants also would be required to disclose what's called Scope 3. You know, the emissions upstream and downstream the value chain, but only if such emissions were material or if the company had made a commitment that referenced Scope 3 emissions. So if you've made a commitment, or if the information is material, it makes sense to measure and report it. The Commission proposed different requirements for Scope 1 and 2 on the one hand, as opposed to Scope 3 on the other, as methodologies for determining Scope 3 emissions currently aren't as well developed as the others just yet. And the proposal would phase in Scope 3 a little later than the Scope 1 and 2, set a new liability safe harbor with regard to Scope 3 disclosures, and small reporting companies would be exempt from Scope 3. So let me close on feedback from the public, because this is just a proposal. And since the proposal has been released, we've already gotten a lot of feedback, some of it for the proposal, some against. That's what we need to hear. And we need to hear the reasons too. We need to hear all sides of this. We consider all of those comments in determining whether and how to adjust the release as we move forward. We look forward to and will benefit from your public comment on all the key areas of the proposal. So if you're weighing in for or against, it's really helpful to understand particularly where you are on each of the topics: strategy, governance, risk management, targets, financial statement metrics, greenhouse gas emissions, and particularly how you're using this, if you're using it, in terms of investing, or from the issuer side, how you're seeing it be used. And I know that some aspects of the proposal might be of interest to certain commenters more than others. But if I can be clear, we are seeking feedback on every line item relevant to you as a commenter. If you're using something as an investor, it's part of your investment decisions. It's helpful to understand those economics and what we've got right or what you think should be adjusted. It'd be good to hear from both issuers and investors, and of all sizes, from all corners of the US. That includes those who are involved in this conversation already, like your investor relations departments, your chief executive officers, your chief financial officers, and yes, as Mindy said, boards of directors. And what are investors asking of you? And how do you and your competitors decide what disclosures to make? What would help bring greater consistency, comparability, decision usefulness, if I can say that again? And what are the economics? We encourage a wide range of investors, from individuals to institutional, to hear from chief investment officers and people managing pensions and endowments. What helps you and facilitates making your decisions? That's our role. That's where we can come in and bring some consistency. So it begs the question, how do you comment? Go to really www.sec.gov. Under our regulation menu, click on proposed rulemaking, scroll down to the proposal at March 21st, 2022. There you can find the release and the comment forum, and it will be terrific to hear from as many of you as we can. And thank you, and I look forward to any questions Mindy or your others want to ask.
So we have dozens and dozens of questions coming in, and we have about 5 minutes left with you. So I'm going to try and integrate some of them or summarize them. Otherwise, we'll be here until next Wednesday. We will get them to your staff.
All right, that's terrific, Mindy. But if you want to take 10, it's all right. I'll take whatever you want. Okay.
There's some question about the Commission's legal authority in this area. People are wondering scope of the SEC authority. There are plenty of examples, I presume, but if you could address that, that would be great.
Look, I think I tried to address that just in my opening remarks. I think this is just in a long tradition. Our legal authority embedded in the 33 and 34 Acts and so forth are about full and fair disclosure. And companies are making such disclosures. The hundreds of companies are making such disclosures, and investors are currently making decisions based upon those disclosures. So our role is really to help bring some consistency. One might call it some standardization to those disclosures.
Great. Let me ask, consistency in the United States will be terrific. What are you seeing? How are we going to get aligned on a more global level when there's not a system that says every country shall have the same standards, but how do we harmonize global standards in some way?
Look, part of this is based upon the work that's already been done by these various frameworks and protocols, TCFD and the GHG. Part of it is done on a daily basis by and amongst issuers and investors around the globe, talking amongst themselves and doing something consistently. But we have a role too at the SEC, and we've been talking to our counterparts, both multilateral through the Financial Stability Board and something called IOSCO, but also bilateral. And there's barely a week that goes by that counterparts at jobs similar to mine get on the phone, or at the staff level get on the phone and compare. But now that we have a proposal out, it's best to hear from you all. What did we get right? What do we adjust? What dials to turn to, as I say, achieve that consistency?
Another question I've seen many of amongst the dozens is, what happens if companies don't do what they're supposed to do? Everyone's going to interpret it in their way. Is there enforcement that will follow up? How will you make sure it gets done?
Mindy, I hope that we sort of can get through a proposal and implement based upon comments, and I don't want to prejudge, but if we adopt, there's a number of years of implementation and the like. But yes, over the decades, we also have a large corporate finance unit that reviews filings, whether you're going public through an IPO, an S1 filing, the filings for mergers, and yes, the annual reports, the 10K. So I would hope that first implementation, then of course, consultation with the Division of Corporate Finance around review of the filings. But ultimately, sure, there's also an enforcement part of it. But I want to sort of get through the proposal, hear from the public comment, and see if we could potentially adopt and implement.
The final comment that I'll ask you, given there are a lot of questions about a broader world of ESG, which I know you're acting on, but this rule is about climate. How do we tell some of these 1,000 people what's going on beyond your important work on climate risk?
So I thank you for that. We've approaching those disclosures that are either happening now or investors find material to their investment decisions. We've put the proposal out on climate risk. We've actually, I know you might not call it ESG, but we've put out a proposal also about cyber risk, companies' disclosure about their risk management strategy, and yes, even incident of having cyber risk incidents. And that's too, because this is a material thing that's going on in our economy right now, cyber risk. We have ongoing work around human capital disclosures. We have ongoing work also in the fund space about investment funds and the disclosures they make. But again, we'd like to hear from you all.
Great. Terrific. Thank you for taking the time. I know your staff will be on for a good part of this call. We'll hear from companies, investors, and from experts to drill down a little bit more on what's in the rule.
And if I can just say this, Mindy, as people listening, think about this. If you think we've got something right, tell us about it. If you think it should be adjusted, tell us. But the more detail and really line by line, and particularly how investors are using it in their investment decisions and how issuers are finding, you're having these dialogues right now with your investors. And that's going to really benefit the 5 of us on the commission.
Terrific. We will keep at it. We thank you for your work, and we'll talk soon. Thanks so much for your time.